Welcome to the Legal View with Farah and Farah. And I'm Chuck Farah. With me today is Eddie Farah, my partner. Eddie, what's on your mind?
Well, Chuck, we're going to talk about the accident report privilege today. And anybody who's been involved in an accident in Florida has had to deal with this particular statute because under Florida law, there are certain people that are required to give information to the investigating officer. And that is anybody involved in the accident, whether it's a pedestrian, driver, or passenger in the vehicle. That information that you give to the police officer at the scene of the accident can never be used for or against you in a court of law. Let me give you an example of that. Let's say you're involved in an accident. The at-fault driver comes over to the police officer and admits to the police officer that he ran the red light. Well, you cannot use that statement against him in a court of law. And the reason why you can't use that statement against him is, first, the accident report privilege requires you to give information to the police officer, and secondly, because of the constitutional right against self-incrimination. So for those two reasons, nothing in the accident report can be used in a court of law to either prove or disprove your case. Even the police officer himself cannot come to court to testify as to what was told to him at the scene of the accident. A lot of people, and we've seen this happen several times, many times in our office, they'll be involved in an accident and they'll kind of refrain from hiring a lawyer at the beginning because they'll say, well, the other driver got the ticket, he ran the stop sign or he ran the red light, let me just see how my medical condition progresses and I'll hire a lawyer maybe 6 or 7 months down the road. That can be a dangerous mistake because a lot of times we see people who received traffic tickets end up denying they caused the accident when it comes to a court of law. And you can't bring in the ticket and wave it in front of the judge or the jury to say, Mr. Smith received the ticket for running the stop sign. So we always encourage our clients immediately hire a lawyer because we can do our own physical investigation of the accident. Because even though we can't use the accident report, our investigators can go to the scene of the accident. They can interview witnesses who weren't involved in the accident because those statements would be admissible in court of law. And we know how people are. As time goes on, people become less interested. They're not apt to cooperate and provide a witness statement. Sometimes their memories fade, or there are other things going on in their lives where they really don't want to get involved in helping someone out. So you always want to talk to a lawyer right after you've been involved in an accident, no matter how clear-cut the liability is.
Yeah, this takes me back again to my law school days when this rule of evidence, this is a rule of evidence. I mean, in court, there's certain types of evidence that can come in front of a jury and certain types that can't. You're talking about a piece of evidence that isn't allowed to go in front of a jury. And I always wondered, why would this report not be admissible to a jury? And just like every aspect of the law, there's logic behind it. And in this case, the logic is that the legislature wants people at the scene to give information freely to the police officer. They don't want witnesses or bystanders to think that, oh, well, I'm not going to give any evidence here or any testimony to the police officer because I don't want to be drawn into this whole matter in court. And so the legislature then set this rule of evidence in place to prevent that type of information from coming into court, so that just opens up the line of communications between witnesses and the police officer.
That's why it's so important to do your own investigation after the accident and recreate the accident on your own through your attorney, because that evidence is admissible. If an investigator goes out to the scene of the accident and he finds the debris in a different lane of travel, and that's valuable evidence, he can photograph that evidence to show the accident maybe happened in that lane. There are skid marks that can be, photographed. So there's a lot of physical evidence that can help your case regardless of what the accident report says.
Right.
And don't even be discouraged if you receive the ticket. Because again, even if you receive the ticket, that ticket is not admissible against you to prove that maybe you caused or contributed to the accident. A lot of times we'll go to a scene in an accident and there's a shrubbery or a piece of vegetation that covered up the stop sign that probably caused the accident to happen. And it was never even mentioned on the accident report. So that's why it's always important to contact an attorney that has an investigator on staff that can be dispatched immediately to the scene of the accident and do what needs to be done regardless of how many tickets were given.